Welcome to this webinar, which is a short introduction to the EU regulation on shipment of waste, the WSR regulation. The aim of the webinar is to present some of the most basic obstacles that prosecutors can come into contact with when dealing with infringements of the regulation in criminal cases. My name is Kristina Persson. I am a senior public prosecutor and serve at the National Unit for Environmental Crimes within the Swedish Prosecutor Authority. I have worked with environmental crimes for nearly 14 years, which includes waste crimes. I am also a member of ENPE, the European Network of Prosecutors for the Environment. Within this network, prosecutors from different member states meet and discuss the many issues of the regulation. In this networking, it has become obvious that the regulation is a difficult legislation and that there is a need for prosecutors to come together and discuss difficulties in order to ensure a uniform application of the regulation in the member states. In the webinar, we will start with an overall very brief background to the WSR regulation. Then we will look into where you can find tools for interpretation of the regulation and if there are some differences in comparison with the interpretation of criminal law. After that, we will look at the regulation and the different control procedures the regulation sets. We will go through which circumstances you need to investigate in order to be able to determine which control procedure that is required for a certain cross-border transport. In this part, we will focus on two central circumstances or definitions: waste and recovery. We will learn how waste and recovery are defined and interpreted, and if those interpretations can be used also in a criminal case. Here we will also look at some court cases. But first we start with the background. The EU regulation implements the Basel Convention and the OECD decision seen at this slide. The Basel Convention was adopted in March 1989 and entered into force in May 1992. There are until the present date 187 parties to the Convention. The Convention is a global environmental agreement on hazardous and other wastes. Its aim is to protect human health and the environment against the adverse effects resulting from the generation, management, transboundary movements and disposal of hazardous and other waste. If you want to learn more about the Basel Convention, you can visit the Basel Convention's official website. The OECD decision was adopted in 1992 and was revised in 2001. The OECD decision contains similar rules concerning movement of waste at the Basel Convention, but with OECD countries involved. For more information, you can visit the OECD official website. As mentioned, the requirements from the Basel Convention and from the OECD decision is implemented in the EU regulation on shipment of waste. In the regulation, there are no sanctions for infringement of the provisions, but the regulation states in Article 50 that the Member States shall lay down rules on penalties applicable for infringements. Article 50 also states that the penalties must be effective, proportionate and dissuasive. In this context, the Directive on the Protection of the Environment through Criminal Law should be mentioned. This directive states that the Member States shall ensure that illegal shipments defined in Article 235 in the WSR regulation are criminalized if they are committed with intent or gross negligence. This means that you find the penalties or sanctions for infringement of the provisions in your own national law. The waste transport regulation is directly applicable in all member states and shall be interpreted and applied in the same way. The interpretation of EU acts is contextual and strong purpose-oriented. This may cause a conflict with criminal law where you find strong principles such as the principle of legality. I will give some examples later of this conflict. But first we will see where we as practitioners can find help to interpret the regulation. How to interpret criminal law, I'm sure you already know. The binding interpretation of EU law is the exclusive competence of the European Court of Justice. On the court's official website, you can find interesting cases, also in waste cases, and these can be of great use. Other sources are the preambles of the regulation and the preambles of some directives of interest, such as the Waste Directive. The preambles are explaining the background and the purpose of the acts and can give you some guidance of how they shall be interpreted. In addition, there are some non-binding EU guidelines which can be useful. First, I shall mention guidelines provided by the Commission in order to achieve uniformity in the Member States. Article 38 in the Waste Directive states that the Commission may develop guidelines for the interpretation of the definitions of recovery and disposal, and the Commission has adopted such guidelines. These guidance can be used as long as they do not conflict with the decisions from the European Court of Justice. Secondly, the Member States has together decided on correspondence guidelines on how to determine, for example, what is waste. We shall look at both of these guidelines later in the webinar. You can also get some help from other Member States' case law. ENPE, European Network of Prosecutors for the Environment, has and still are gathering cases of interest in a database. As a member of the network, you may have access to the database. I will give some examples of cases in the database later. The database is also a great source for comparing national criminal provisions, and you can find help, for example, with the penal value for a specific illegal transport. The Waste Transport Regulation contains detailed rules on when and in what way waste movement shall be controlled for exports, imports, transports within EU and transit through EU, all in order to achieve the main purpose of the regulation, environmental protection. I will now briefly present which different control procedures the regulation requires and which circumstances you need to investigate in order to be able to determine which control procedure that is required for a specific cross-border transport. But first and most important, only movements of waste are subject to the strict procedural requirements of the regulation. The regulation is not applicable at all if the products are assessed to be a used product and not waste. Therefore, the essential first question you need to investigate and prove is it waste? We will soon go into this question more in detail. The regulation states three different control systems for a transport of waste. General information requirements, or requirements of notification and prior written consent, or prohibitions, which could be either exports or import bans. To know which of these control procedure that is applicable in a current case, there is three terms to consider. First, the countries involved in the transport. Secondly, the classification of the waste. The classification is very important and often depends on how hazardous the waste is. You find the classification in the annexes of the regulation. Finally, you need to know which treatment method the waste will go through in the land of destination. Is it a transport of waste for recovery? Is it a transport of waste for disposal? Or is it a transport of waste only for reuse? If you know these circumstances, you can find the relevant article in the regulation. Let's look at an example. If you know that the countries involved are Sweden to Ghana, well, then it is an export from EU. And if the wastes are shipped to Ghana in order to go through a recovery treatment in Ghana, and you know how the waste is classified and can find it in a specific annex, well, then you know that it is Article 36 that is the relevant article, and you then see that the export is prohibited. After that, you can start looking for a sanction in your own national law for breaching the export ban in Article 36. All of these circumstances that you shall consider are of course subjects to difficulties. In the webinar, we will focus on two difficulties: waste and recovery. We start with waste. What is meant by waste is defined in the regulation Article 2.1. And as you can see, the regulation refers to the definition of waste in the Directive 2006. The Directive from 2006 has, from the 12th of December 2010, been replaced by Directive 2008, the current Waste Directive. One question is which definition you shall use, the one in Directive 2006, which the regulation indeed is referring to, or the latter directive, the one that is in force. In criminal cases, this can be a problem because of the principle of legality. It is not a big question when it comes to waste, but indeed it is a question when it comes to the definition of recovery, which we will look back to. The question which of the directives that shall be used in a criminal case has been answered by the Swedish Supreme Court in a court decision from July 2016, court number 1299/14. The case was about an export of waste from Sweden via Rotterdam to Ghana, and the suspect claimed that the items were not waste. The first issue for the court was to decide which directive to use, the one mentioned in the regulation itself from 2006 or the 2008 Waste Directive. You can find a summary of the verdict in the ENPE database. The court states that it is the definitions in Directive 2008 that shall be used also in criminal cases. So, in Sweden this is clear, at least until we have a case from the Court of Justice maybe saying something else. So, we go to Directive 2008, and in Article 3.1 it states that the waste means substance or object which the holder discards or intends or is required to discard. As you can see, the definition of waste is relatively wide. It seems to be the intention of the holder rather than the status of the object, such as age or function, which determines whether the item is waste or not. But how do you prove the intention of the former holder if you have no idea who this is? What shall the police or the customs or an inspector at an environmental agency do when they inspect a transport with items and have no idea of the prior holder's intention? And what do you need as a prosecutor to prove that it is waste? Do you really need to know and prove the former holder's intention? A person perhaps you never will find. As stated initially, cases from the Court of Justice are of immediate importance to find out how to interpret waste. There are a few cases in which the Court of Justice clarifies the concept of waste, and the court seems to pay particular attention to the status of the items rather than to the holder's intention. The verdicts I will mention here, which are non-exhaustive, are from the time before the new Waste Directive, but are still significant. I will just make a short comment of what is important in each case. In the cases C206 and 207 from 88, the Court of Justice finds that waste can have a financial value and that waste is a commodity. In the cases C 418 and 419 from 97, the Court of Justice states that if the item has to go through a recovery or disposal operation, there is a presumption that the object is waste. This cases also states that the term waste is not to be interpreted restrictively, and that if the public thinks it looks like waste, then it is a presumption that it is. But finally, and as always, the court states that despite the above, an overall assessment must be made, taking into account all the circumstances and taking into account the purpose of the Waste Directive. As I mentioned before, the Commission has adopted guidelines, guidance on the interpretation of key provisions of the Waste Directive. The guidelines are not legally binding, but they may serve as a very good guidance in the assessment of waste, as long as they do not conflict with the practice of the European Court of Justice. This is also noticed in the very beginning of the guidelines, which you can see in this slide. The document is a very descriptive document that is well worth reading if it comes into question what is waste. Attached you have a link to the guidance. In addition to the Commission's guidelines, correspondent guidelines has been adopted by the Member States on how the regulation should be interpreted in different matters. They are not legally binding, and you can find the guidelines in the website you can see in the slide. For example, there is a correspondent guidelines number 1 on electrical equipment. This is from number 1 correspondent guidelines about electrical equipment. Here is a listed situation where used electronic equipment should normally be considered waste. 9a states that electronic equipment should normally be considered waste if the electronic equipment is destined for disposal or recycling. As you remember, this was also one of the Court of Justice points in the above mentioned cases. 9b states that used electronic equipment should normally be considered waste if the equipment is not complete and essential parts are missing, and the equipment cannot perform its key functions. This is pictures taken from the website of the Swedish Environmental Agency, where the agency gives examples of when the equipment isn't complete or parts are missing and therefore will be assessed as waste according to the guidelines. 9b again, this is pictures from a Swedish case where the suspect exported refrigerators to Africa. And here you can see the customs documentation of items that cannot perform its key's function, though the power cable is cut off. 9c states that used electronic equipment should normally be considered waste if the equipment shows a defect that materially affects its functionality and fails relevant functionality tests. Or in D, the equipment shows physical damage that impairs its functionality or safety as defined in relevant standards and cannot be repaired at a reasonable cost. And these two pictures, which are from the mentioned Swedish case, is a good example of what the Court of Justice clarified in the case you see here. If it looks like waste, the presumption is that it is waste. And finally, E. Here are some pictures that highlights 9E in the guidelines. It states that used electronic equipment should normally be considered waste if the protection against damage during transport, loading and unloading operations is inappropriate. The picture to the left is from a Swedish case where the customs inspected a container that was going to be exported to a third country. When they opened the doors, the item just fell out. And this could be an example of inappropriate loading. The documents, the guidelines, are made by environmental authorities, and one question is whether these guidelines can be used in a criminal case to prove that the items are waste. This was a question in the above-mentioned case from the Swedish Supreme Court, which, or at least a summary of it, is to be found in the ENPE database. In the case, a person exported televisions and a car from Sweden via Rotterdam to Ghana. The transport was stopped and inspected in Rotterdam, and the person was prosecuted in Sweden for breaching the export ban in Article 36. The suspect claimed that the items were used products and not waste. The Swedish Supreme Court stated in the question whether it was waste or not the following. It has been noted that the definition of waste can create difficulties, especially when you want to determine if something has become waste or has ceased to be waste. It may be necessary to test the holder's purpose and decide whether the holder wants to discard the item or not. However, the court stated, in assessing the question whether the holder intends to discard the objects that he or she has, you must in practice take considerable account of the external circumstances, such as the condition of the object, age, functionality, and packaging. The court found it proved that the televisions were dirty and damaged, they had no remote controls, and they were insufficiently packed. Even the car was in poor condition and it leaked liquid. On arrival in Rotterdam, the car was not properly anchored and the car had damage to the roof and the windshield. The car had furthermore a driving ban in Sweden because the brakes were rust damaged. The court found that it was clear that the objects were in such a condition that they could not be used for the purpose without repair or other recovery operations. Therefore, the court considered the television and the car as waste. As you can see, all these circumstances are to be found in Correspondent Guidelines number 1 and from the cases from the European Court of Justice. So, this Swedish criminal case shows that the correspondent guidelines and the cases from the European Court of Justice can be used also in a criminal case to assess if items are to be defined as waste or not. And this makes it, of course, easier to prove if it is waste or not. All these external circumstances that shall be taken into account, such as age, function, packaging, and so on, is possible to see at an inspection and easy to document by the inspectors to bring to court as evidence. And this shows that you don't have to find the previous holder for an interview.